This is a time set for oral argument. Our case number is JV1939. Each side is allocated 20 minutes for argument. Appellant may reserve a portion of that time if you choose to do so for rebuttal. If you choose to do so, you need to keep track of your own time using the podium clock. Out of respect for counsel, I would ask that everyone who is present make sure that your phones are turned off so we avoid interruptions of presentation and embarrassment. We have read the briefs. We've conferenced the case. We'd encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and then will be posted to YouTube as well. So as you approach the podium, I would ask that you state your name and the party that you represent. With that, Ms. Reeves.
Good morning. May it please the court, my name is Christina Reeves and I represent Father Aaron W. Your Honors, the dependency proceeding against Father should never have been brought in this case. The trial court abused its discretion when it found that the state had met its burden to prove its alleged grounds for dependency, and this petition should be dismissed. Parents have a natural, moral, and a constitutional fundamental right to the custody of their children. And in Arizona, our legislature has codified that right into Arizona statutory law. ARS 1-601A states, the liberty of parents to direct the upbringing, education, healthcare, and mental health of their children is a fundamental right. From the moment the state took custody of Father's children in this case, it has continuously and repeatedly violated Father's rights to his children and his children's right to have a relationship with their father that was unmired by state interference. And it's time for that to stop. We are asking this court to dismiss the dependency in order that the state return Father's children to him, as they should have done almost 2 years ago. When the state took custody of the children from Mother, they conducted absolutely no investigation. They did not even ask Mother for Father's contact information. They made no effort to contact Father. They never talked to him. Yet they filed a dependency petition alleging that he had neglected his children. They alleged that he had not paid child support. They alleged that there was no custody arrangement. The Attorney General verified the truth of these allegations without conducting any investigation into them.
Well, could we fast forward a little bit because the time is short?
Yes, Your Honor.
Talk about what was actually found, because in the previous appeal, this court specifically found that there was sufficient evidence in the record to support a dependency petition as it related to failure to protect.
Yes, Your Honor.
And the trial court in this case also found that. So can we focus just for a minute and talk about what evidence does or does not support the dependency finding by the trial court in these proceedings as it relates to failure to protect?
Of course, Your Honor. The state alleged that Father had neglected his children by failing to protect them from Mother's substance abuse and domestic violence. The court found neglect on that basis, but in doing so, the court failed to tie the allegations that the state had made to the actual statute that the legislature has mandated as what conduct will constitute neglect. The state is not free to define neglect in any manner that it chooses, and then to say, hey, we proved our allegations, therefore we proved neglect. The state has to prove that the conduct that they alleged amounted to neglect under the statute. They have to prove that there was, at the time of adjudication, an inability or an unwillingness of the parent to provide supervision, food, shelter, clothing, or medical care. The trial court never made any finding that the father at the time of adjudication was unwilling or unable to provide anything. The words inability or unwillingness don't appear anywhere in the court's ruling. It never made a finding that the father was unwilling to provide supervision.
Can I ask you a question? Did the evidence change at all regarding what Father did or didn't do during the period of time that mother had the children here in Arizona that was the basis for the failure to protect?
What had changed at the time of the adjudication in this hearing from the time of adjudication of this court's original decision was that mother was convicted of various counts of armed robbery and sentenced to confinement for a period of 11 years. So this court found implied in its decision that the neglect could be ongoing because there was a possibility that mother could again get custody of the daughter or of the daughters, and again engage in substance abuse and again engage in domestic violence, and that father may possibly again fail to intercede. That possibility was no longer in existence at the time of this adjudication. There was no possibility that at the time of this adjudication that there was an unwillingness to supervise his children and protect them from mother's substance abuse and domestic violence, because that was not a possibility. So there was no possibility of finding an unknowing neglect. And the trial court pretty much acknowledges that, because even though it finds the neglect from a failure to protect from mother's substance abuse and domestic violence, that's what it found that father did to neglect. When it goes to finding the continuing neglect, it switches and it changes the definition of what the allegation of neglect is, and now says it's continuing neglect because father has been a victim of domestic violence in the past, and there's a possibility, even though the court acknowledges there was no evidence that father's current wife was violent, that maybe, possibly in the future, his wife could turn violent, and maybe, possibly, maybe, that he would fail to protect his kids from violence. But there was nothing in the record, and the court never made a finding in the record, that father had ever failed to protect his kids from his own victimhood of domestic violence. So that could not have served as a basis for continuing neglect. Not only did the court fail to adhere to the statutory definition of neglect, of what conduct will constitute neglect according to the legislature, it switched the conduct that was going to be the basis for the neglect finding halfway through its ruling. And that is a violation of due process. Father cannot possibly defend. He was told he had to defend against a charge of neglect, and so he had to show that he had the ability and the willingness to provide supervision and food and shelter, and that if he hadn't provided supervision, that at least that lack of supervision hadn't caused a risk of harm to his kids, and even if there was a risk of harm, that risk of harm wasn't unreasonable. Under the statute, when the state charged him with neglect, that's what he knew he had to defend against.
Counsel, though, I understand your argument before we get to what you're pressing, which is kind of a due process notice argument. I also understood your argument, at least from the briefs, but help me, that you couldn't do that consistent with what the statute requires.
Yes.
Okay, I wanted to make sure I wasn't missing.
Yes, because the statute, the state can't say you've neglected your kids because you fed them popsicles for dinner on 3 occasions, and then prove that you fed the kids popsicles on dinner for 3 occasions and say, we proved neglect. They have to prove that the conduct amounted to neglect under the statutory definition of neglect. And here the court did not hold the state to that burden. It never found that the state had proven that father was unable or unwilling to supervise his children. He never made any finding that lack of supervision is what caused a risk of harm to the children. Nor was there any evidence that he could have.
Well, okay, I'm going to have to call you on that one. Because the court found a failure to protect twice. And in Aaron W1, we said, yeah, there is. Given his conduct and his behavior, there is evidence that he failed to protect these children from mother's bad behavior.
Exactly, and I'm not arguing that there isn't.
So we just were clear that at some point in time, there was evidence of a dependency, and father failed to protect the children from that dependency against mother. And so
I'm going to disagree with you on that point. I would agree that there was evidence that there was failure to protect during that 6-month or 3-month period, depending on which evidence the court's looking at, that he didn't contact mother, and he only contacted grandfather and got assurances that he was okay. And during that time, but whether or not, in this court's opinion in Aaron W., the court cited the neglect statute and said, this is the neglect statute, this is what the court has to prove. It's possible that these allegations can satisfy that statute, but you still have to go back and prove it. I didn't read the court's opinion to be relieving the state's obligation to prove every element of neglect as the legislature had defined it.
But what we did say is that we had to look to see if there was evidence to support the dependency as it related to father, or we would just dismiss it.
Yes, Your Honor.
And we looked at that evidence and we said there was a failure to protect based on the evidence presented. And
Yes,
Judge
Your Honor.
Gordon, reviewing the evidence, said, yep, there's a failure to protect. And I asked, that was my first question out of the box, has that evidence changed? Because he wanted to call mother the due process issue that was involved in the first dependency term. So did the evidence change? Is it related to what father did or didn't do when the children were in Arizona and he lived in Colorado?
No, the evidence didn't change. The evidence was the same. And I'm not arguing the court's finding that that evidence the state can build upon that evidence to prove every element of neglect, but they still have to do it. Maybe the evidence does show that, but the state still has to prove that it satisfies every element, and the court still has to find that it proved every element. And here the court didn't do that. Because the evidence could possibly prove the offense doesn't mean that it did, or the state had no obligation to prove that it actually proved every element of the offense. And again, what you look at, even though the evidence of that time period in 2015 or 2016, that didn't change. We're talking almost 2 years later. And you have to look at whether or not the children are dependent as to father at the time of adjudication. And at the time,
that's based on mother being incarcerated. That's your argument, is that change has occurred because mother's incarcerated.
mother is incarcerated for 11 years. So the court found that there was a possibility of ongoing neglect because the argument had been, well, he can't neglect them while they're in DCS custody. And the court said, well, no, you can still be found to have neglect even when the children are in DCS custody because you're going to get them back. But here, it's not that they're in DCS custody is why there's no ongoing neglect. It's because mother is in prison, and there is no possibility that she is going to be released from prison, get custody of these children, resume her substance abuse and domestic abuse bad decisions, and that father is going to fail to intervene. Father has been fighting for these children for the last almost 2 years. There is no indication that he would just walk away from them, even if that remote possibility ever happened. And the court never found that. And instead, it had to rely on father's possibility of his nonviolent wife someday turning violent and father possibly not protecting his children from his nonviolent wife. That's what the court had to rely on in order to find that there was continuing neglect. And that's not allowed. And one of the other things that I wanted to respond to quickly is the state's assertion that it didn't have to provide reunification services during this dependency, because that it doesn't have to provide unification service, that it didn't have to make efforts to reunify this family from the time it took custody of the children until there was a dependency, that they have no obligation to try to reunify the family. That is not true. Under ARS 601B, the state has, in order for a state to infringe on the fundamental rights of parents, they have to ensure that that infringement is narrowly tailored and done in the least restrictive means possible. That imposes on DCS an obligation to make every effort to reunify the family the second that they start to infringe on that fundamental right. So that is a false declaration by the state. If there are no further questions, I'm going to reserve the remainder of my time.
Very well. Thank you. Ms. Falcon.
Good morning. May it please the court, my name is Joanne Falcon and I'm representing the Department of Child Safety in this matter. Some preliminary thoughts. Your Honor, Murdy, you are absolutely correct. Nothing has changed evidentiary-wise between this court's first finding that sufficient evidence supported the finding that father had failed to protect his children from mother. The only thing that has changed, as Ms. Reeves mentions, is that mother is now incarcerated. But that doesn't change the fact that father is the one who was aware of the fact that the children were in danger, aware of the fact that he had not had contact with them for a year, and knowingly did nothing to protect them from a woman that he knew to be abusing substances and domestically violent.
Well, I agree with you, and that's why we said in our W1, yeah, that's correct. But we specifically went on to say that you have to show the next step. And I'm going to look at my notes here. In the Arizona Supreme Court case, matter of appeal in Cochise County Juvenile Action number 5666-J, and thank goodness we don't cite to our cases like that anymore. The Arizona Supreme Court said for a parent to prove failure to protect, you have to prove first the conditions were sufficient to declare a child dependent, which, given Aaron W1 and what you just said, and Ms. Reeves agrees that the facts, the predicate facts have not changed. That, I think, is met and met. But it's 2 and 3 that I have concerns with and I would like you to address. And 2 is the threat giving rise to those conditions remains unresolved. And 3, the threat continues to pose an imminent risk of harm to the child. So I think now you have to convince the court that Judge Gordon addressed 2 and 3 and made sufficient findings to show that there is a continuing threat, even though mother is now in prison and will be for the foreseeable future. And the threat continues to pose imminent risk of harm to the child. And in that case, the one I just mentioned, the mother, as I'm sure you know, the mother refused to get medical care and one of her children died. And the department was trying to take the others and using the threat, failure to protect. And our Supreme Court said it's not a failure to protect until one of the other children gets sick and it's an imminent risk to that child. So where's the imminency in this case, and how has the matter not been resolved?
I will be happy to address both of those things, Your Honor. Thank you. The threat giving rise does remain unresolved. In this case, the juvenile court did find that father had testified, he reported to his therapist that, quote, every woman that I've been around is violent. He reported that these women believe they can get anything they want. The court did note that there's no current evidence that father's current wife posed those exact risks. There were serious concerns about her mental health, including the attention-seeking behavior and self-harming. In addition, father testified and other people at the hearing testified, including father's former wife, mom to the children, she wasn't the wife, the significant other, the mother of the children, that father's relationships tend to be short-lived. He goes from one woman to the next and engages in violence with each of them, and many of them have substance abuse problems. At the end of the trial, Madeline, father's current wife, testified that they were splitting up, that she was planning to move out because she just couldn't deal with this anymore. And so
This being
the situation, this case,
this case.
and the effect that it was having on their marriage. Additionally, father was opposing the court's reasonable request that his wife undergo a mental health evaluation to determine whether she posed a risk to the children. The fact that he was so unwilling to recognize that there's a potential risk to these children and address it is evidence that he would continue to fail to protect those children should she actually pose a risk, or should some subsequent woman down the road pose a risk to the children. He was more invested in protecting...
Counsel, if the threat, the original threat and the evidence that we've been talking about relates to the mother who is now incarcerated, is it consistent with our case law to shift to a potential future threat from another person who is yet to be defined as a threat. My understanding of the case that Judge McMurdy was referencing, the Cochise County, et cetera, case, is that it's that threat giving rise to the neglect, which was the threat of mom who's incarcerated, that threat remains unresolved, and that threat that is unresolved poses an imminent risk. How can we have this sort of shifting factual scenario?
And in that case, it's been a while since I've read it. My understanding of it, though, was that mother had in fact failed to take the children to the doctor in that particular case, but that it wasn't certain that she would fail to
Oh, no,
take
she
the child.
said it. It says right in the paper.
Okay.
I
apologize
won't do
then.
it in the future.
Okay. Then I would submit that perhaps that case was wrongly decided, and under the more recent
Okay, well,
case.
you get to tell the Arizona Supreme Court.
Well, under the more recent Shella H case, though, it does talk about if that risk
Sorry, which
remains
case?
unresolved. The Shella H case, it's cited in both briefs,
Okay.
I believe. I think they had titled it Sheila H, but it's Shella, Shelllah. I can get you a case site if you want me to. But in that case, the court did find, in that case, the parents had engaged in domestic violence. The father was in jail or prison at the time with not much likelihood of him returning, and nevertheless the court found that the threat remained because mother had such a huge long history of failing to protect these children that it was pretty obvious that the risk remained. In the Cochise County case, you had one incident. It doesn't necessarily mean, and again, it's been a while since I read the case, mother may have said, I will not do it, but if I'm remembering correctly, and correct me again if I'm not, it seemed like the court found, yeah, but perhaps she might change her mind if it happens. We don't know that. But when you have a situation...
That went to the imminency.
Right, but when you have a situation where over and over and over again, father has been in relationships with violent women who abuse substances, and he's in a relationship with a woman who he admits is potentially mentally unstable and is fighting every effort to have her mental health evaluated, I submit that that is an imminent risk to the children. And then the fact that she's now saying, we're breaking up and who knows who he's going to be with next.
How, though, does the fact that they are ending a relationship, doesn't that resolve the issue?
It might resolve it with respect to this woman, but the bottom line, the underlying
And let
theme...
me follow up, and I'm interrupting you, and I know that, but what then other person is identified as opposed to the possibility that some point at some time in the future, father might affiliate with someone who has behavioral health issues that would cause a concern about his ability to parent?
And again, he is right now, even today, in this appeal, fighting the effort to have mother or his wife's mental health evaluated. He is currently exposing the children to a risk and failing to protect them.
No, but my question was
He's still
different
doing
than
it.
that. My question was different than that. It was building on your statement that the trial testimony was that his current wife is leaving, will not be in the home.
Mm-hmm.
And if I heard you right, the concern that you expressed was, gosh, father at some point in the future might affiliate with another significant other and have a close relationship. And that other significant other might in turn have behavioral health issues that might implicate his ability to parent. Isn't that what you were arguing?
Well, additionally, they haven't split up yet. So
No, but is
that risk remained at the time of the dependency hearing.
But just pretty narrow question. Isn't that what you're arguing?
I am arguing that the risk has persisted so completely and in every relationship in the past and persists to this day in the current relationship where he's refusing to have the wife's mental health evaluated, that it's beyond this, well, maybe she will, maybe she won't take the child to the doctor the next time. She says she won't, but we don't really know. And into the realm of, until father has demonstrated that behavioral change of recognizing those threats and being willing to protect the children, that is a higher risk. It may be
So let me ask a couple of hypotheticals, because they're not this case.
Mm-hmm.
Father instead at trial, in this trial, the second trial, says, we are ending our relationship, my current wife is right, and I vowed that I will never have a relationship with anyone else. Could the court find the children dependent from your perspective on that factual record?
I would disagree under Shella H and under any semblance of reasonableness, but under the Cochise County case that you cited, perhaps I would maybe need to read that one closer. But
And
that's not this case.
I thought the thing that I struggle with, and again, it's a dependency, not a severance. So I thought the children came in care given largely concerns expressed about mother's behavior and father's failure to protect from mother.
Right.
Did it sort of migrate somehow since then, or?
Yes, because it wasn't just that he failed to protect from mother, but also that he, in general, is not capable of protecting them.
Would I find that in the petition?
Well,
I thought in the petition, the only thing they alleged was abandonment, failure to protect, and risk of emotional abuse. We can get to risk of emotional abuse here in a minute. But weren't those the three bases upon which they filed the petition?
yes, those were the three bases. And
no court has found abandonment, both the
Correct.
first trial and the second trial.
Correct.
And we said in Aaron 1, risk of emotional abuse required an expert, which you didn't present at the second proceeding. And so the only basis upon which we have before us is failure to protect. Did I do the chronology correct?
Yes, Your Honor, and that's the only basis that the juvenile court found. The juvenile court did find that it believed this court had erred in its prior decision, that if allowed to do so, it would have found the other basis about the risk of emotional abuse, neglect, but it didn't make that finding because this court had previously said that it would have required expert testimony. So, but nevertheless, under the statutes, if you look at the neglect statute, it's defined as the inability or unwillingness of a parent to provide that child with supervision if that inability or unwillingness causes unreasonable risk of harm to the child's health or welfare. So I submit that in that Cochise County case, perhaps the court found that, okay, we had an issue, but we don't think it's an unreasonable risk because we're not sure that it's going to be an ongoing problem. I submit that in this case, we can be, or the juvenile court certainly was, and the question is whether the juvenile court has abused its discretion. The juvenile court was certain that this was an ongoing risk, an unreasonable risk of harm to the children's health and welfare.
Well, in the Cochise County case, I mean, there was absolute risk involved. Mother had allowed one of the children to die. And when pressed on whether she would get medical care for her other children should they become sick, she said, no, I won't. I mean, what greater risk do you have than in that scenario?
Well, and again, that was, one incident, and again, perhaps the court felt it's a severe one. And you're right, there's always sort of a balance of what is the depth of, or the amount of risk and how likely is that risk to occur. And so perhaps the court in that case felt that it was a low risk of potentially pretty high damages.
The children weren't going to get sick,
but
there's a low risk of it.
Well, or perhaps they wouldn't catch anything life-threatening, or perhaps she would change her mind and take them to the doctor. In this case, though, you have a long history of father not protecting the children, not protecting himself, not being capable of it, demonstrating that he currently, to this day, is unwilling to protect the children because he's fighting tooth and nail the court's order to have his wife undergo that mental health examination. He's
also fighting the dependency finding.
He's fighting.
And if he wins that, the court would lack jurisdiction to do that.
Sure. And again, he's welcome to fight that. She's welcome to refuse to comply. But when the court identifies a risk, such as a potentially mentally unstable person that the parent is living with, that can be a reason for not returning the children to that home until that risk is resolved in whatever way. Whether it's by having the wife do a mental health evaluation and it comes back fine, or perhaps the father engages in services and therapy and learns to identify the risks that are relevant and learns to take the steps to protect the children. The reunification services are yet to come. This is just the dependency stage. So far, father has not been particularly willing to engage in things. He didn't go to the first appointment with the very first psychological evaluator, and then he was so obstreperous with the second appointment for that first psychological evaluator that the evaluation couldn't even be completed. Even by the time he got to the evaluation with Dr. Giuliano, he was on its face cooperative, Dr. Giuliano said, but he was evasive and contradicted things that he said and didn't really demonstrate any ability to be honest and forthright and to identify what the actual issues were that he needed to address.
There was an ICPC home study done.
Yes.
Did the jurisdiction that was conducting that study find anything about mother, did not mother, about his current wife?
Yes, the Colorado home study did come back and recommend placing the children with father on the condition that mental health concerns were addressed.
I thought it was a bonding assessment.
And a bonding assessment, yes. And they were concerned, but there throughout the report are notes about concerns about both the wife's mental health issues and father's potential mental health issues. And thus the bonding assessment was required to determine how the children interacted with father because
And
they
even though
didn't
it wasn't
have.
presented at the dependency proceedings, there has been a bonding assessment completed, hasn't it?
I believe that came through after the dependency proceedings were
said.
done, so that would not have been in front of the court.
Well, I know that. I asked her that.
Yeah. And my understanding is it has been completed.
It was favorable.
Somewhat, and in some ways not. So if this court is going to consider it at all, it needs to look at it as a whole.
Oh, it's not before us.
Okay.
Can we talk about the risk of emotional abuse?
Certainly, I'd love to.
I'm perplexed that the department would take the position that a mandate from this court that says this is what you need to present in order to prove this would be dicta. Could you explain that to me?
Well, yes. I didn't take that position in the brief on appeal, but I can understand what the trial.
You still represent the department,
and
so I get
what they
to
were
understand
arguing
that.
below was essentially father had argued due process. The court reversed on that basis, found one ground for saying, yeah, there was enough evidence to not dismiss this thing entirely. Didn't even need to address the other issues, and that makes those other issues dicta as it's traditionally defined. In addition, this court.
Again, I just refer to my notes. Let me read you what it says, and then you tell me how that plays into it. Dicta, when a court says, this is what you're going to do in the future, in a particular case, is not dicta. It's known as judicial dictum. It's a statement that the court expressly declares to be a guide for future conduct and is therefore considered authoritative and must be followed. Isn't that what we had in this case?
Absolutely, and that is why I didn't argue that issue for this court. And I think that the juvenile court did the right thing. I do agree with the department's position that this court may have misunderstood where that requirement goes. If I may just have a little leeway, I could explain why the juvenile court thought that this court got it wrong. And it is law of the case, but this court, can revisit that. The definition of abuse is the infliction or allowing of physical injury or infliction or allowing another person to cause serious emotional damage. Okay, so abuse is defined as infliction of or allowing another person to cause serious emotional damage. In addition to that, inflicting or allowing sexual abuse is defined as abuse. Neglect, however, is essentially defined, and again that's in 25A, as the failure to provide the child with supervision if it places the child or causes an unreasonable risk of harm to the child's health or welfare. So that would include placing the child at risk of harm for abuse. So a parent hasn't actually abused the child yet. We don't have actual emotional abuse. But that doesn't mean that the department has to stand by and wait until the child is damaged before taking some kind of protective action, such as engaging the parent in some therapy so that they learn not to place the child at risk of emotional abuse. And
but
I think
if you want to do a dependency, if you believe that's the case, don't you have to get an expert to come in and testify to the court to say, yes, there is a risk of emotional abuse because of X, Y, and Z?
The emotional abuse is defined, I'll find that page, it requires the testimony from the medical professional. But the neglect standard doesn't require testimony from a medical professional or psychologist. So we did in this case have testimony of a counselor, can't remember exactly her credentials, but the testimony's in there, that the children were at risk for the abuse. They had not yet been.
And the previous panel that heard this case didn't believe that was sufficient.
I don't think they got into as much detail, in part because they had already decided that there was enough evidence on the failure to protect. I could be wrong. My time is up. I'd be happy to address it further if you like.
Thank you, counsel. Ms. Reeves, rebuttal.
Thank you, Your Honor. Judge McMurray, just to respond to your question about the bonding assessment that was recently completed, it was favorable to father in that it recommended that the younger two children be immediately returned to him and recommended a transition plan for the older child. It's not before this court, but you asked, so I thought I'd let you know. A couple of things. The state spent a lot of time arguing about father's possible potential failure to protect from his own victimhood of domestic violence against a potential threat, which may or may not be his current wife. That's not the grounds that were alleged in the petition. And as Judge Perkins, as you pointed out, the case law does not allow for the state to switch its basis for allegations of dependency halfway. And it certainly doesn't allow it to switch between a finding of neglect and then switch that basis for finding of continuing neglect, which is what happened here. And that cannot stand. The state also stated that it could investigate the possible risk that father's current wife poses, and that they were free to keep the kids while they investigated that possible risk. This court rejected that argument in Donald W. This court said the state cannot keep a legal father's children from him while they conduct an investigation into his unfitness. They have to have some grounds to believe that he is unfit. They can't.
Well, I have some grounds in this case. There was a failure to protect. That was at the time of the original dependency finding. There was actual evidence that we've said, both trial courts have found, and we have found, that there was sufficient evidence to support.
For
So
that,
that's not Donald
no,
W.
that not on that basis though. The court did not find that there was a concern for the children being dependent as their father because his failure to protect them from his own victimhood of domestic violence. The court said there might be that risk, but it didn't find that it didn't make a finding that father had ever failed to protect his children from his own victimhood of domestic violence, nor could the court make such a finding based on this record. The testimony was that when mother in this case became violent with him, that he had his son sent to his mother, who's a different mother in this case, so that he could get away from that domestic violence. He sought an order of protection against his wife. He wasn't successful at achieving one, but he sought that order of protection. He encouraged the mother to go to anger management counseling, and she did go to anger management counseling. And when it didn't resolve their problem, then he divorced her. I mean, not divorced because they were never married, but then they separated, and he pursued custody of the children in order to keep them from her. So the evidence was that when there is domestic violence and he is the victim, he does take steps to protect his children. And there was no finding of otherwise in this case. So the findings that were made by this court, made by the lower court as to the dependency, the court abused its discretion in making those findings. Its findings of fact do not support its legal conclusion that the state had met its burden. Neither could the state meet its burden if this court was to remand based on the evidence the state has already presented. The allegations in the petition do not include a risk of domestic violence when father is the victim. And like I just said, there is no evidence that father fails to protect his children when he is the victim of domestic violence. So we are asking this court to set aside the finding of dependency and reverse the lower court's decision. Thank you.
Thank you, counsel. We appreciate your briefs. We appreciate your argument. We will take this matter under advisement. We'll issue a written ruling in due course. Court stands adjourned.